Live from New York, it's Ask a Lawyer and a Couple Engineers.
Hey everybody, it's time for that show that you love. Every Wednesday at 8 p.m. we do this thing. It's me, Lady Ada, the engineer. With me is Mr. Lady Ada, who's on camera control. We also have two special guests today, two lawyers. She'll be talking about all sorts of lawyer things. They're also super hardcore, and they have opinions about anime. We're broadcasting here from the Adafruit factory. We do all the design, engineer, manufacturing that you know and love. So we have an exciting show. We're going to jump right into it.
All right.
What is into it?
Okay, the code is arguendo. 10% off in the Adafruit store, all the way up to 11:59 p.m.
If you can
Eastern
spell
time.
it, you get 10% off.
Arguendo.
If you can assume it,
If you can assume it, you can get the code. That supports us. Adafruit, an open source hardware company in New York City. Here's us. We have no loans, no venture capital. We do live programming with live lawyers. Support us. Talk about the show and tell. Might get to the mailbag, a little bit of time travel. Made in New York City, Internet of Things, 3D printing, new products. We'll answer your question, might have top secret. We'll do trivia, all that and more on Ask an Engineer. Some of the stuff we might not get to tonight. Depends on how legally
But
we
that
get.
just means next week will be even better.
Yeah. So just a quick programming note. This is Ask an Engineer, 8 p.m. every Wednesday night. Show and tell we just did, 7:30 p.m. Do that every Wednesday. Same day shipping is back on. Thank you everyone for your patience. And not so thank you to that one guy who tried to get same day during the blizzard. Free UPS ground on all. I'm not kidding. Free UPS ground on orders $200 or more.
But you promised.
Continental to continental US on checkout. And shipping is resumed. Thank you everyone for being patient. There was a state advisory. There was notices on our site and everywhere.
We're not allowed to ship things. Everything was closed. Yeah. We did our best.
Yeah, we're here to make sure our staff is safe. So some of us made it into the office. I had a 360 video of me trekking to the office and more. So thank you for your patience. So without further ado, Lady Ada, we had a show and tell.
Yeah, I'll go through the show and tell
Yeah,
fast.
go through it really quick, and then we get some lawyers.
Okay, we start off. We had three people from Adafruit team. Tony D showed up and talked about the MPR 121 capacitive touch driver for CircuitPython, MicroPython. Check that out. If you would like to use the MPR 121, a lovely 12-channel capacitive touch sensor, you can use that with any board that runs CircuitPython or maybe even MicroPython. There's a video about it and a GitHub tutorial and GitHub repo, and the tutorial will go live shortly. Jump Park showed off his gigantic ninja timer, which will show the video either this week or next week. And there's also a guide live on the site right now. Build your own gigantic 6-digit NeoPixel timer, glowy buttons, like things that you smack. You can climb on ropes and then figure out your time. He has a friend who runs a ninja box. I don't know what the hell they're called. It's like a CrossFit, but they do more rope things or less rope things. And he talked about the techniques for diffusion, for getting the buttons to work from far away. A lot of commenting. A lot of people want to build gigantic timers, so I thought this would be a good project. Known Pedro's project, 3D printed LCD shutter glasses. We got these shutter glasses in the store. Everyone's like, make some glasses. So we did. We have a set here. We make the lawyers wear them. And they're also working on making some custom feather boxes for use with feathers. So this is going to be for some accessibility projects. Yep. Then we had a lot of visitors. We had Matt, who built a infrared Raspberry Pi airsoft sentry gun that he will shoot you with as like a video targeting system. It's kind of scary. Yeah. He'll probably kick your ass in airsoft. Rebecca, who left a lovely voicemail and is also working on a circuit playground plus weather sensors for people who have chronic diseases that can be affected by the pressure and temperature.
Also know what the weather is inside.
Also know what the weather is and inside. Yeah. So check out her project with Circuit Playground. She'll come back when she's got even more done. Adam is continuing to work on the eBay electron scanning microscope. He's got the oil pump working. The vacuum is so strong he actually can't get into the microscope anymore, so he has to somehow get that not working so he can work on the electronics. He'll come back next week, give us more updates. Richard A. is still at the Living Computer Museum in Seattle. Go visit the Living Computer Museum. It's super cool. They have living computers. And he's going to be hanging out with Punished Props. They make cool cosplay props, and they're going to be doing some LED projects. He said he's not so good at props, and the Punished Props fellow is not so good at electronics, but together they will be good at everything.
Yeah, a lot of people have teamed up from the show and tell. They've come on, they've met each other, and then they've done projects together.
Nice.
Not so bad. The internet is more than a box of wires. It doesn't do anything. Right. Sometimes.
Chris Young visited. He's working on the IR driver that he had for the AVR. He's porting into the SAMD processor. Chatting about how to get some accessibility projects for SAMD chipsets, which are very powerful. And he also, so he updated that driver, got working on any pin, learned a lot about timers on the SAMD, and also designed a 3D printed puzzle and shared some tips on how to do dual color extrusion on a MakerBot by doing some tips and tricks.
Yeah, you have to,
hacking
the 3D printer he has, it doesn't pause, but you can hack it to stop for 30 seconds. So you have to quickly swap out
Very
the filament.
fast.
That's cool.
Change filament. And then Nader visited. He's coming in from Tunisia, which is pretty cool. I don't think we've had a Tunisian
No, yeah.
on the show before. Yeah?
Yeah.
That's so cool. We have
I think we've hit almost every continent.
We've definitely hit every continent.
Yeah, we got to get them before they go underwater.
Yeah. He had an Arduino plus TFT screen project. He's kind of built like a smartwatch.
Yeah.
It has apps. It can play Flappy Bird. It has timekeeping.
Yeah.
He's adding a lot of graphic stuff to it. So using our libraries. Really cool project.
Yeah.
Like doing a lot with only a few components to make a very
You know you got a good project
complicated
when it
UI.
runs Flappy Bird.
It runs Flappy Bird.
Okay, that's it. All participants on the show get an as seen on the show and tell sticker. Email support@adafruit.com and we'll send you out one. That's part of our Adafruit Live series. We've been doing a lot of Desk of Lady Ada with payphones. Tony D has some videos this week. Tuesday, just a little programming note. You didn't think it was possible, but it is. We're interviewing Altium. They're a Eagle CAD competitor. They make CAD software. They're on the prowl. Autodesk got Eagle, and now Altium is like, but hey, we got stuff for makers too. So
We'll interview them.
We did an interview with Eagle, and now we're doing an interview with Altium. Ted, the CTO, is going to be on. So please post up your questions for Altium on the blog post.
You have questions for Altium? We will ask them for you.
Yeah, we're going to ask the tough questions.
Ask an Altium
Ask an Altium.
next Tuesday.
Tuesday. Okay, without further ado, I've said that twice, but I'll say it again. Welcome our friends from Leeson Ellis.
Yay.
All right,
Hello.
introduce yourselves.
Hello.
I'm Marty Schwimmer, and this is my colleague Jordan,
Hi, nice to meet you all.
and we have been privileged to be Adafruit's intellectual property attorneys for years and years.
Yeah.
Years and
You've
years.
grown, we've grown with you. We've had an interesting amount of things that we needed to do as we grow and grew, and you've always helped us out.
We figured out how we know each other, actually. Went to a Dave Weiner meetup
Yeah.
and met Bree Pettis at that.
People think there's nothing that's going on in a Dave Weiner meetup, but connections are made.
People talk about Dave Weiner in the back of the
RSS
room.
feeds, XML feeds, connections.
So I began representing MakerBot as a result of meeting Bree, and then you must have called Bree and said, hey, I need a lawyer.
Yeah.
And that's how it all came about, and that's why
Actually,
we're
we
all
didn't
here.
need a lawyer, and that's why I asked, because I didn't need one at the time.
Well, very often people wait
Yeah.
until they need a lawyer.
And that's what we're going to talk about tonight.
And that's like the number one piece of advice.
Yeah. But before we get started.
Hire us before you need us.
Yeah.
Yeah.
Well, we couldn't afford a lawyer when we first started, so that's what we're going to talk about tonight. Good practices, things to do at different levels of a company. Say you want to start a business. But one thing that we should say, anything tonight is not legal advice. In fact, we have a pair of glasses that say that.
Are they on?
Yeah.
they're on.
This is supposed to say this is not legal advice.
That's what it says. It just scrolls slowly.
Yeah.
Legal advice would be followed by a bill. I think
That's how you know.
A guy named Bill, or just like you mean an invoice?
no, he delivers our bills.
All right. So Marty and Jordan, maybe tell us a little bit about yourself. What field of law is you special in? What type of things you like to?
What's your favorite anime?
Yeah.
Favorite anime? I guess that would have to be Ninja. I'm sorry. Favorite anime would have to be. I'm not going to say Ghost in the Shell because it's a movie out, but I am going to say maybe Akira.
Okay.
Okay.
Classic.
Marty, you got anything you want to say?
I got kids, so we like the Miyazaki stuff. So
Okay.
Spirited Away would probably be my favorite.
That's totally fine.
So it's
Okay.
not all lady justice thing in this house in these houses. There's other things that you lawyers do.
no,
Yeah,
we
no.
watch anime with our kids.
You watch anime with kids.
Or Star Wars on a snow day.
Okay. You're both kind of makers, and that's I think one of the reasons you like working with Adafruit. You see our products out.
Yeah.
You said Jordan before we got started, someone was using our stuff with some assistive technology.
Yep.
And I
Yeah.
don't-
No. Well, I'm a patent attorney. I went to school for bioinformatics, so I'm more on the software side of things. But I definitely like making, and we do a lot with a lot of clients who are in that space, from guys who are startups to guys who are running their own factories to Fortune 500. But I always have a special place, at least in my practice, for guys who are just getting started, who are building stuff in their own garage, because I like technology and I like helping out people who love it.
Gotcha. And Marty, what do you like to do besides the anime and kid sting?
Mostly arguing.
Hence the code.
No.
Arguendo. 10% off. Gotta pay the bills, sorry.
And here's the hint. It usually uses assuming arguendo in a case, which means assuming for the sake of argument that you were telling the truth, then this would be the situation. That's where it comes up, arguendo.
Do you need to know Latin to be a lawyer?
Passim. No,
Pick it up?
no. You're told it often enough that you kind of know what you have to do.
Yeah.
Ceteris paribus, all things being equal, you really don't need to learn Latin.
Well, I'm going to set this
Okay.
up a little bit. For the folks who are on the tweets and more, sometimes Adafruit retweets and stuff. So, Marty, you have, I think, the best, or at least maybe the most successful.
Well, certainly the first.
Yeah, trademark blog.
Yeah, that's why I was pretty much the first IP lawyer to blog. That's how I was able to scoop up the name, the Trademark Blog. So this is like since 2004. But as I get older and lazier, I really do mostly tweeting. So at Trademark Blog is the Twitter thing.
Okay. And you covered like really interesting things that I look at and Lamar looks at because we have to see what's going on. There's been like uniform cases with cheerleaders, like what's actually protectable or not. And a lot of these things, there isn't a clear answer, hence you have to go to court sometimes.
Thank God.
Yeah, you have a job, but it's also it's always interesting stuff. I think engineers and they like to look at legal cases because engineers have a very divide up things into categories and try to make sense and have rule sets, and that's kind of what lawyers don't do, right? It's like keeping things out of the rules. So it's finding the exceptions.
So there's actually a divide in thinking between patent lawyers and trademark and copyright lawyers. So
Is this going to be a fight?
No.
Oh.
No. It's a way of thinking that's differently, but we all learn to get along with each other.
Okay.
So our firm is about 35 attorneys, and about a little bit more than half are patent attorneys. And they have to define things very, very narrowly because there's nothing new under the sun. So they have to squeeze in their invention. And that's why they have to they view things very, very narrowly. And trademark lawyers, if you've ever received a demand letter, you know that trademark lawyers believe that everything is related to everything else, and that if you were aware of Nike for shoes, then you couldn't possibly use Nike for wine.
Yeah.
So we have a different way of looking at the world.
Yeah, I could straight up say, like, when we decide to do a product, we do a bunch of research, and then we come up with a name. We try to make something unique, and we make sure it's something that people would recognize once they see it. And then we usually rely on your firm. Does it make sense to do worldwide, certain territories, and usually we figure out the best way to proceed. So I guess starting off, if someone is going to start a company or any type of business, what are the things that both of you would like to say to, especially this like pro maker audience? They might have a Kickstarter, they might be thinking of doing a product.
It's just them, maybe one or two people.
Your audience is a little bit smarter and better looking than my clientele. But I've been people have been saying I have an idea for a business to me for about 29 years at this point, and they kind of fall into two categories: those which can develop their idea fairly far along, and those who really can't. And there's people who they get an idea, they've been using a certain, like a pocketbook or something, and they think of a small improvement, but they are not engineers or whatever, and they can't really develop the idea, and they're kind of at the mercy of having to disclose the idea to strangers. The people that we saw on Show and Tell, obviously they could really prototype their idea, they can develop it, they can get a lot of experimental data, and they're in a much better position when they get to the point where they have to disclose an idea.
The system changed though, so now there's a first to file, right? Is that how it works?
Yeah, well, the United States a couple of years ago made a change to the way that its patent law worked. Before then, we were sort of unique in the world. American exceptionalism sort of running rampant, where we were a first inventor system. So as long as you were the first inventor, it didn't really matter so much how you got to the patent office. If you were the first guy, if you were the 10th guy, as long as you could show that you were diligent in working on your invention. So you were working on it for 10 years and you had lab notebooks and,
It's clear that you were working on this.
Clear that you were working on it. We've recently changed to a new system, which is kind of a hybrid of what the rest of the world has and what we used to have. The rest of the world has a first-to-file system, so it's a race to the patent office. It doesn't really matter who's been working on it longer, who came up with the idea first. What we have now is called this hybrid first inventor to file. So there's still a race to the patent office, but if you can prove that the guy who beat you to the patent office got the idea from you, you'll win. But you'll only win in that limited circumstance.
Gotcha.
In
What
all
if it's
other
two independent people, but the second independent person filed first, but the first independent person can prove that they were working on it earlier, what happens then?
the guy who got to the patent office first is still going to be the winner in that.
Gotcha.
The only way you can really use that I was working on it longer argument is if someone can prove that first guy to reach the patent office was somewhere influenced by you. He snuck into your garage and took pictures and then filed a patent application.
So what if they saw a YouTube video?
There is it can get technical, but there are a couple of issues with sort of YouTube videos. And that's something that everybody should know, is that in the United States, you have this grace period. You've got a year to file from what's known as a public disclosure. So a YouTube video going to a maker faire and disclosing whatever your concept is, essentially that sets the clock running. You've got a year from then to when you'd have to do something at the patent office. And there are a couple of different things you can do, but you've got a year. If someone else saw your YouTube video, and you can prove that they saw your YouTube video, it's a straight copy, maybe you had some nice colors and flags that went along with your invention that are just obvious that he just didn't come up with it on his own, then that's that first inventor to file, because you're the first inventor, that guy is clearly not the inventor, he copied it. You win. But if it's just two people in two different garages working on their own, and on Monday you go to the patent office and on Tuesday he goes to the patent office, you win.
So prior art's a little different now.
It is. It's been a change, and it was designed to bring the United States into harmonization with the rest of the world. A lot of times the rest of the world said, look, that's not the way the system works, but U.S. companies wanted to have a more streamlined approach to global patent filing, and so this is what we've got.
Well, I've got a story, but I have a question. So how do you prove if someone maybe saw a YouTube video? You posted it up and you're like, I think that person saw my video and decided to...
Or they was taught a maker faire.
Yeah.
Or,
It can be complicated. I mean, it's one of the reasons why you would call a patent attorney, right? Because it's not really something where you can just sort of sleuth on the internet and make that determination. There are long and unfortunately really complex and expensive procedures at the patent office, which are called derivation proceedings, where you have to essentially prove that someone would have had access to your idea and that they went and filed it and that they didn't really make patentably important changes to their idea before it happened.
Yeah, I could tell you a story. This is a public post, I wrote about it on Make. Scholastic made something called BristleBots. And friends of ours had something called BristleBots. They showed it off at maker fairs. They were selling it as a kit online. And when Scholastic made a book about it and didn't credit them, and that's all they wanted, they're open source geeks. All they wanted was credit. And they said, we've never seen this. We came up with it independently, even though it's identical, even though it's called BristleBots. We've never seen it ever. And so Evil Mad Scientist Laboratories were in a jam. They're like, Phil, now there's a book, and we just want credit. They never wanted to get paid. They never wanted anything. And they said that there's no way anyone ever saw it. Completely came up with an independent. So I kept asking them. Eventually, I talked to their PR person, and his last name was Good. They always get these guys who when Tylenol kills a kid or something, they have this really good PR person. So this one's really good.
great hair.
Super good hair. So we got on, hey Phil, we want to work this out. So we kept going and going and going. And at the very end, I said, all right, you're convinced that no one in your organization ever saw it. So it was for Klutz Books, and it was Scholastic. And what had happened was years ago, they saw the Evil Mad Scientist laboratory video, and they clicked like. And it was screenshotable with the date. And once I submitted that to them, they credited Evil Mad Scientists, and they gave them a tour, and everything was resolved. But they kept pushing and pushing and pushing, saying there's no way, there's no way, there's no way. But that is how that story ended, and that's why I was asking, how do you know? In this case, they, using their public account from their business, years ago, time-stamped, clicked like. and that's how it was discovered.
Lawyers love that because
It's really that clear,
Yeah,
with a
but-
timestamp and a click.
But what's funny is, even though everyone was saying, we know you saw it, like, it's obvious it's the same thing as the same product. You made a book about it. They just want credit. They're not suing, but that was the end of that story. So anyways, that's the post on Make. Yeah.
So I have a question, because I want to actually give an example of what actually tends to happen a lot in the maker movement. I'm actually going to use Chris Young as an example because he talked about this. So Chris Young, he's on the show and tell, and he's actually developed this really cool accessibility Bluetooth interface that lets people who don't have full muscular control use iPads. And he actually used it at the hospital where he went to the hospital, and the doctors were like, "Oh my God, you should patent this." And he actually is not interested in patenting. He loves open source hardware. And so he said, I don't want to patent this. In fact, I want to make sure it never gets patented because I want to make sure that he wants to publish it and make sure as many people as possible can build this accessibility device because he's a good person. Not that people who get patents aren't good people, but he believes in that. So what would somebody in that situation where they're like, I want to make sure that it doesn't get patented because I think this is such a useful invention for the world, what can they do?
There was an old legal phrase from a judge that says sunlight is the best disinfectant, right? If you want something to be open, you have to be open. You have to publish it. You have to be open and notorious about it. You don't
Notorious.
Have to, you don't have to make. You don't have to.
These
make
are
a
great
product.
words tonight.
Doesn't mean quite what. Just means
Notorious open source hardware.
No,
Would you
it
say
means
Adafruit is
public.
notorious?
They are.
No, in a good way. It's
In the
you get
pejorative
out.
sense of the term, yes.
Absolutely. And, I got a
B.I.G.
tattoo a long time ago that said notorious, and so now I think it makes a lot of sense.
There's a lot of circular
Notorious.
today. there's a lot of
The
zen.
best thing to do if you want to do open source is to publish as much as possible.
Absolutely.
Blog it
Absolutely.
up, tweet it.
Pictures.
And put it on as many sites as you want.
Explainers,
Shut up
you know.
on show. And what is that protecting you? So basically, if somebody else did try to patent it, you would say, I was notoriously outgoing with this information.
What it will function as is publicly available prior art. And so when you try to get a patent, one of the things that the patent examiner's job is to do is to sort of look both in the records of all the patents that have ever been filed or all the patents that have ever been granted in both the United States and worldwide, but also to look in what's called the sort of the common resource of knowledge of the world. And now that's the internet. It used to be trade journals and technical things, but patent examiners will go on the internet and they'll look and they'll see, are these concepts known or are these concepts documented in a way that what you've come to me at the patent office with is clearly something that you didn't invent or clearly something that was invented already. There's not a big requirement in the patent office that you not know something. It's that thing has to have not been done before.
Gotcha.
So you could independently create it and honestly feel in your bones that you came up with this idea and you're the first one, and you'll find
They're like, no, the Swiffer already exists. Sorry.
40 years ago, one of the things that we find as patent attorneys that's sort of interesting to me is that a lot of the concepts that we have now, including how we do things with microcontrollers and computer implemented sort of physical products, people were trying to do 50, 70, 100 years ago. They were trying to do it, but they were trying to do it with gears and steam pipes and all this sort of wild machines. But the underlying rationale of what the problem they were trying to solve is still the same problem. And so sometimes sort of compressing things down into electronics doesn't solve that problem for you because that concept was known. So if you get those ideas out into the world, they function as that stop against someone else coming on later.
So
after
publish early and often.
Publish.
So
publish.
One thing we do is we do open source hardware, and we do give everything away. We want it to be shared. However, you can't say you're Adafruit, and that's why we have trademarks. And so to switch over to Marty, what are some of the things that you wanted to talk about in this maker world of business and trademarks and things to think about? We have some questions, but I know you had some topics you wanted to cover.
Well, we got to the intermediate course fairly quickly. I was still thinking about, you say to your friends, I've got an idea for a business, and can you trust them or not?
Jordan just took over there.
I did.
It's quite okay.
Well, actually in the chat, all the questions
stuff.
that people were asking, you were answering.
Right.
Yeah.
Well, it had more to do with get it in writing as quickly as possible. We're in this funny situation, kind of like a domestic relations lawyer when the couple in love, I guess I shouldn't use that example. The couple in love comes in. And you say, well, there should be a prenup because, someday he's going to cheat on you, right? So friends come in and say, hey, we've got this
Handshake
business
agreement.
friend,
Yeah.
and there's a problem because people contribute and people aren't good at valuing their contribution. So one guy has the technology and one person has money and one person has a sofa, and you go, okay, let's handshake, and 33, 33, 33. So then 2 weeks into it, wow, they're not showing up for the meetings. I'm kind of getting annoyed
And
by
the
this.
sofa has bed bugs.
And the sofa has bed bugs. So how could that be worth 33% of this? So it's difficult, but you've got to get it in writing, your understanding, as quickly as
Does
possible.
email count? Because I hear that all the time.
Email is a writing.
Okay.
And also sometimes if you're afraid to get the other person to sign something, you could do something unilateral. You could write an email. Hey, further, it was great meeting you today. And as we discussed, you're going to do this in exchange for that. And that kind of puts the onus on the other side to say, no, actually, that's not what we're
So
doing.
follow-up
right?
notes.
Follow-up notes.
So follow-up notes, documentation, and even if a little reticent, maybe an equal split is not such a good idea. It's better to have a bad deal in writing now than to go 2 years into the venture and then try to pull it apart.
You hear
at
about
that
this all the time.
This
'Cause
happens so often.
Companies will spin up really fast. They'll get investment. Someone wants to buy them, and then there's this mysterious person that's disappeared. Nothing was in writing, or it was a bunch of emails or instant messages or sometimes Snapchats.
And you suddenly discover that
That's
the
true.
domain name of the venture was registered to only one of the people and not in the name of the venture. And
I've never heard
suddenly-
a story like that exactly. Oh wait, I've heard that story a lot. No, that's why you have to be careful. If you have a company name, you might have to
for
get.
a few seconds there.
Yeah,
Just now.
well, if you have we have every
It's like,
form
how
of.
could you not have heard that
Oh, yeah.
all the time?
we have every form of Adafruit, but that still doesn't stop people sometimes from trying to domain squat.
Well, domain squatting is certainly a problem. And also we're kind of talking about name clearance. It's harder and harder. People like us do something called name clearance, which you come up and you say, hey, we want the name Adafruit, and we search and we advise you two things. Can you use it without being sued? And will you be able to sue other people? Will you get exclusive rights in the name? It's a little bit harder than it was, when I was starting out, which is now you really kind of want the guessable domain name. What I mean by
typos.
that is that it works both ways. If people encounter Adafruit.com, they assume that a company named Adafruit is the source of that. And if they heard that there's a company called Adafruit, they assume that it's Adafruit.com. And I think that the new top-level domains, .guru, .club, .whatever, has not yet changed that assumption. The problem has gotten even worse. Now they're going to expect you to be at Adafruit on Twitter.
Yeah, we just got verified recently, and there was fake accounts.
That reminds me of a file on my desk.
Yeah.
One of the things that's important is that if you do decide a name, one thing we do is whenever there's a new service, we always register just so
On
we
the social
have
media
that name.
platforms. And
So we have like Adafruit on Elo. We don't really use Elo,
Yeah.
but it's like it's
You never know.
You never know. You might
Yeah.
as well just go register.
we also have a nice community where if they see Adafruit available, they'll scoop it up and hand it over to us. That's pretty nice. So I think in addition to getting in writing is really good, of course, and doing the due diligence on some of the
And
names.
some of these things have to be in writing.
Yeah.
There's something called a statute of frauds, not a statue of frauds. And for copyright, at least, it has to be in writing for the rights to transfer. So this comes up where you hire a coder and do it on a handshake, and then there's a falling out. For you to have taken title to that software or the graphics on your website or anything copyrightable, there has to have been a writing that says, I, the creator, transferred all rights that I may have to you. And that's certainly the case of copyright, at least. It's not true of trademark, for example. But another situation where people are kind of scared. That part of IP counseling is kind of psychological counseling, which is when the venture is new, people are sometimes scared to stand up for themselves, or they're scared of this is going to be the fight that's going to break up this fragile venture. And my advice sometimes is that of a therapist, which is that have the fight now rather than the fight 5 or 10 years from now.
Gotcha.
I had a situation where it was the circulation of the contract that led to the crack up, where once they were talking to each other about
Oh, that happens a lot.
Yeah, I mean, once, wow, this person is a jerk. Look at how he's insisting about this clause.
And legal language sounds harsh sometimes.
Yeah.
Well, it's very hard to confront people. People tend to not value things, or they tend to overvalue their contribution. Again, have the fight now than 2 years
Gotcha.
from now.
Okay.
This actually, just to jump on that point, this actually comes up a lot in patent law. In patent law, inventors are anybody who's sort of meaningfully contributed. But what you want to do is you want to assign those patent rights to a company. You mentioned sort of that due diligence. All of a sudden somebody is interested in the company, and you say, we've got 5 patents, and it turns out it's only in one guy's name, engineer 3 floors down. And then you ask him, can you assign all the rights to the company? And he says, well, no, pay me 30% of the company. You always want those things sort of in writing as early as you can get them, because the way that, at least in the United States, patent law works is that the inventor is the owner, not his job, unless he has an agreement with his job. And the way the patent office sort of treats things is that unless it's really clear to them that you had some sort of prior obligation to give them their patent rights, things you invent belong to you. And
Which is actually kind of cool, which is really nice. It means the inventor owns it until they reassign it.
right.
Or
No
if it was agreed upon when they started, who owns it?
If they signed an agreement which is why a lot of engineers, when they work for a company, there's an agreement for intellectual property transference, all the copyrights and trademarks and patents belong to the
I'd say we
companies
do
they were
something
inventing.
that allows us to attract really smart people and allows them to do everything they want to do, which is we do open source. So the assumption and the agreement from the beginning is, here's the licenses we use, and this is going to the world no matter what. It has to be this license. So I have a follow-up question. Creative Commons. I'm going to just speak for me, in my opinion. I think Creative Commons non-commercial really messed up stuff, because you're giving away something and you're sharing it freely, and what non-commercial means or doesn't mean is really weird on the internet, because there could be ads on the site. There's server hosting and photography and other things.
FedEx is having a huge fight with this right now.
Yeah. So have you ever looked at some of the Creative Commons things? You as lawyers have any opinions?
I used to use a Creative Commons license when I first had the blog, and I had a problem. If you Google the expression, Schwimmer is an anal retentive pinhead, then you will find a dispute that I had when blogging was young and people thought that RSS was actually going to be a moneymaker.
I remember that.
There was a company called Bloglines.
I remember that too.
And what it did was scoop up people's blog feeds.
Yeah, I think they did that to Make when I was there.
And then they would do
Ads.
They would frame it, and not only that, they had this bizarre terms of service, like on their users or on their page. And you didn't know who was subscribing to your RSS feed.
That's right.
But somehow they would be able to know, or they'd have people sign up. So they would know who my readers were, and I wouldn't, and they weren't going to pay me or anything.
And they put ads around their RSS
Right.
feed.
So, and the ads, in my case, would have been for Trademark Mill. So this is like the worst case scenario, that I'd have this great trademark content and...
It's your name and your words being used to sell Trademark Mill services.
All right, I'm afraid that you got me into storytelling mode.
That's what we're here for.
So I know how to write a nice letter. So I write a nice letter to the CEO of Bloglines. And I'm saying, this is, you can talk to me, we can have a conversation about you syndicating my content. But for now, not so great. So he writes back a really nasty response. So then I write back saying, okay, we're done, which created a nice error message for like a couple hundred subscribers. It turned out that he was being purchased by Ask Jeeves, like the next day. So I caught him at a bad moment to threaten his business model.
Yeah.
So there were a lot of people who thought that RSS was going to be a good way of making money, of monetizing blogs. So over the weekend when this happened, a lot of those people were having horrible things like me. Scoble, for example.
Oh, yeah.
Not that I bear grudges after 14 years. And he reblogs the Schwimmer is an anal retentive pinhead article, thus amplifying it. I called him up and said, my oldest kid is old enough to Google my name now.
Yeah.
And that's the first hit.
Yeah, there's real people.
By Monday, the adults were back on the internet, and there's actually a post that says Schwimmer is right. So I printed that out, because how often is it?
Yay!
Okay. And you got it via RSS, I assume. Everything was working after that and everything.
Yeah, and then it became then it became the dominant form of the internet.
Yeah. Okay. No, this is good. A lot of the stories that I think people tell are the worst case, because you don't generally need lawyers in courts if things work out, right? So some of the questions that were also on here, if folks don't have time or money for a lawyer and they're going down the patent route, what can they do? Just document everything? What can they do if they're just not able to afford a patent, but they think they're going to want to get one?
If they think they want to get one of the answers is there's something called a provisional patent application. It's not really advisable if you're not a patent attorney to try to file patents on your own.
It's like representing yourself in court.
Right.
You can do it.
You can do it.
But on the other side of the spectrum, there are these sort of invention help, invent tech. George Foreman sells a lot of these products that advertise on late night high triple-digit cable channels about, we can help you get this up. Those guys are really a bad idea, and I say that just because they sort of do it they do it in a sort of a warehousing of your idea. They sort of take your idea, they put a lot of boilerplate around it, they don't understand it, they charge you almost as much money as a patent attorney would charge you for it, and then they can accidentally disclose your information.
We've heard horror stories. And people are like, I tried to do the inventor whatever thing I saw on TV, and it didn't work out.
In fact, the Patent Office, the U.S. Patent Office, has a list on their website of those types of companies that you just shouldn't use because they've gotten so many complaints from people who use those services where they lost their patent rights. And these were sort of reasonable people who had ideas that they wanted to patent, and they just sort of, it fell apart on them. So what I usually say is, you don't have to get a patent unless you're sort of afraid of a couple of things. And if you're afraid that you're going to go out into the marketplace and people are going to rip you off and they're going to copy your ideas, that's the time to sort of sit down and think about why you need a patent. And you can sort of document everything and you can get it all together, but as you sort of reach that life event, when you can sort of change your health insurance because you've gotten married or you've had a kid, when you reach that life event that you're going to hit that publish button on the Kickstarter, or you're going to go to the Maker Faire and you're going to show everybody what it is, you have to have an honest conversation about how comfortable am I if I don't have a patent and somebody else takes this idea and they become a millionaire.
And there's a risk that you may not be able to get a patent, as you said. A lot of times it takes a very long time. How long does it usually take? Of course, there's always exceptions, but the bulk of patents, how long does it take from, I want to start filing to you've been granted?
The timeline can vary, obviously. The Patent Office has these categories where they dump technology.
Yeah.
And sort of on the lower end, in terms of speediness, there's sort of your straight mechanical inventions. And on the long end, there's all your biotech and your genetic engineering.
Tweeting mailbox. I got a tweeting mailbox.
You've got
Let's say I could patent it.
If you could patent your tweeting mailbox, you're looking at maybe 2.5-3 years before something really gets going in the Patent Office. And what will happen is the Patent Office will come to you and they'll tell you either you've got it or you don't. And that starts this process where if you've retained a lawyer, you and that lawyer are going to go back and forth with the Patent Office trying to get a patent on something. And that process can then go another 2 years. So you're looking at, from the day you wanted to do something, about 4 years out. And a lot can happen. Technology changes, and you've sort of been working and spending money on this idea for the last better part of half a decade.
And again, it's every situation is different, but about how much would it cost someone, not necessarily your firm, but for most firms, is it $100, $200, $50,000? How much does it approximately cost to get a tweeting mailbox idea patented?
I would say the all-in cost from getting the patent written to the day the Patent Office tells you, here's your patent with the ribbon on it, you're looking at about $8,000.
Okay.
Now here's the business person in me always encourages associates when they're giving estimates to break it down and give them time frames.
Yeah.
So it doesn't sound as daunting as that. So start off with the search.
Okay, so you do a patent search.
You can do a patent search. The patent search will run you a couple of $100 for a search of what we call the patent databases, which is sort of a look through the United States patent database that'll tell you what's been patented or attempted to be patented. Once you get past that, then you want to sort of write your patent application, which will be a couple of $1,000 because the patent office is particular about the words that they want to hear. They're particular about the format. It's a very stilted document. I don't know if many of your listeners/viewers have ever seen a patent document, but it's not written in what would be considered fully idiomatic English. There's a lot of words that have alternative meanings in patentees, and in order to do that right, and those words have meaning because there are laws and there are cases and there are litigations behind what each one of those words meant. The difference between comprising and consisting is a really big deal in patent law, and the is a really big deal in patent law.
So I have a horror story, sort of. This is for the makers out there. We were emailed and said, I have a patent pending thing, and you can't make something that you're currently making and shipping because I have a pending patent. Now, this was years ago. They never got their patent, but they were...
That's another thing, again, by the way, just because you have a pending patent doesn't mean you're going to get it.
They were very mean. They were jerky.
They weren't nice.
And they said, well...
They didn't call me a pinhead.
Yeah. But they said, you should stop doing this. I'm not going to show you the patent. I'm not going to tell you more, but I have a patent pending for something that's kind of like what you're doing. Or close enough. And
you don't have to tell me more. We handled that.
No, I know.
I know, but they don't know.
They don't know.
They don't know.
They don't know. And the first, I have to say this is the one piece of business advice about the getting in writing and some of the due diligence. Things are not as scary as you think. You do have to go through it, though. It's scary to get an email that says, I have a patent on the name Ask an Engineer, and I have an HVAC show. We got that. That was one of the first things you helped us out with, which is a weird thing to say because you don't have patents on words and all that, but yeah.
Okay, so
it's not as scary as you think.
So let's kind of do a universal advice about lawyers' letters. All right. Number one, you get a lawyer's letter, and it's on good stationery sometimes, right? And it says cease and desist in all sorts of double words, which is actually interesting. It has to do with the fact that the Norman French had conquered England, and for a while the court systems were bilingual. So cease and desist was both the French and the English words for stop.
Oh,
little fun fact. Okay,
Lawyer
anyway.
trivia here
Now
on
you know
Ask
why
an
it says
Engineer.
cease and desist.
That's right. Okay.
Okay.
So you get these letters, and they are drafted to try to induce a layperson to cave immediately. Okay. Now, there's certain laws about the cease and desist. They're not allowed to lie, strangely enough. And also, if they go too far, you could actually sue them for a variety of theories. But they were calculated to scare you, and it's a natural human emotion. Okay. And they'll also give you a deadline, which is
usually 2 days after
thing,
you.
right?
It's already happened too.
And if the lawyers are really playing with fire, they will say that the letter is confidential, and were you to duplicate it and give it to somebody and not follow your first impulse, which is to post it on the internet, then you're guilty of copyright violation.
Oh, that's a good one.
So speaking of, thank you for helping us recently on a couple things. We got a patent troll who wanted to, I'd say, do us harm. It's not nice. And they basically said, they used that tricky thing. We'd like to welcome you to our portfolio. So just give us money. And they went away. But is that one of the tricks?
Well, not that I would ever indicate what I might have and told you at that time, but in any event, it's part of this larger advice.
Yeah.
First step, chill.
Chill.
All right?
Chill. It's gonna be okay.
So if the letter says you must respond, you must do this, or we're going to sue you, and the laws will entitle us to $1 gazillion trebled if you don't think.
Yeah.
Okay, all right. Chill. It is a good time to go to a lawyer who practices in that field, who can tell you that they can read the subtext. And at this point, there's a nuance about, I can tell who's really about to go to court the next day and who is just
Yeah.
not.
It's like engineers learn how to read data sheets. Lawyers know how to read these letters. It's how
Yeah.
to communicate.
And
Right.
the problem is everyone's scared to
Right.
talk about this because the patent trolls, they use this language. It's very intimidating, and they know that you might not share it. Because if we all started sharing these kind of bogus things, then their power would decrease. Wouldn't be as scary.
So if you were to Google the name of the person who allegedly is, threatening you, and Google the law firm, whatever, there are in some cases websites of people who have gotten together and have pooled notes. And not that this would have ever happened to you, but in the case of, for example, these photograph trolls.
Oh yeah, that's happened.
That some lawyers tend to bring the same action over and over again about somewhat suspect copyrightable materials. So a good first step might be to research every researchable bit of information in the demand letter, and then reaching out and responding in kind. But again, remember, the demand letter was calculated to make you cave upon receipt.
One thing that I do is when I get a patent troll with this vague language, I Google the address, and it's always a virtual office somewhere. It's not even a real office. They just, they rent a box. That's usually a good sign.
If by good sign meaning that they're going to go away and you could make them.
Yeah,
right.
it usually means that they don't even have a place to go to.
The fact that they've sent it is not a good sign. But
Right? It means they usually get the address wrong. They spell things wrong. They put the other people's names that they've also threatened. It's really sloppy.
Would you ever recommend that somebody respond personally to a demand letter? No.
Okay, so
No.
this is
Ever.
This is why people are tuning in.
Whenever a lawyer's
here's what's worse.
Okay.
Do not take a telephone call from a person who has sent you a demand letter. Do not call the lawyer. There's all sorts of damaging admissions, or not even admissions, just things you say that can be misconstrued. Do not call the other side's lawyer, because that sometimes is I've seen it, the first reaction, I want to make this go away, they're wrong, I'm going to call them up.
I'm going to talk them out of it.
I'm going to talk them out of it. Someone got paid a lot of money to write you a letter to get something out of you. They're not going to be talked out of anything by a layperson. Please do not call the other side's lawyer. All right. Okay. In fact, they might even say, you may want to go to a lawyer, but this will be so much easier, right? I mean, this is something with the torrents where, funny story, owners of usually adult videos tend to get the IP addresses of the people who they think has downloaded, Naughty Cheerleaders 2. And then they send these people these letters, and some guy calls me up and he says, look, I'm telling you, there's no way that I downloaded this movie. I said, I don't know how to bring this up, but do you have any children? He goes, I have an 18-year-old and a 22-year-old. Okay, that might be an issue for you. But these letters say, you don't want to get a lawyer. You want to send us $600.
Yeah.
That's a business model, a possibly illegal business model. So the demand letters might say, whatever you do, don't go to a lawyer, which is good as policemen stopping you on the street and saying, look, whatever you do, don't assert your rights. So no, don't call the other side's lawyer. Try not to respond yourself. You may make admissions or things that will be mischaracterized.
You can never make it better. You can only make it worse.
That's pretty much a good way of putting
speaking
that.
of a law authority or authority figure demanding something,
Where's this headed?
No, I do have another thank you. We had someone show up here and said they wanted all of Adafruit's customer information, and they wouldn't provide any paperwork. They wouldn't do anything, and they got very angry. And
They pretended to be very angry.
That was
their job.
And eventually, we got served paperwork, and we decided that we didn't want to give up this information. And thank you so much, Marty, for helping us. We went through a process, and we did not have to give up all of our customer information.
So you guys should be happy because they stand up for your rights, and they just don't give out information willy-nilly. And it's a pretty troubling thing. We won't identify the federal agency who showed up unannounced and asked for permission to inspect these premises without citing a statute, let alone a warrant. And
I was screamed and spit at.
He spit?
Yeah.
Yeah, he spit on.
He said he's sorry for spitting on me.
Not on purpose, but
So,
you know,
okay.
there's,
So,
Yeah, no,
there's
it's
a
fine.
lot of fluids.
No, it's okay.
So, although I don't practice that field of law, I'm honored that Philip felt comfortable enough to call me. And I get on the phone with the agent, and I said, "Can you please tell me what statute you're acting under?" And he starts saying, "You're the first person who's ever given me this sort of gruff." He basically said that my asking him questions was evidence of my client's guilt. I said, "No, it's evidence of the fact that I don't know what I'm talking about under this field of law. Can you please tell me what statute it is?" And also,
He didn't like that, by the way.
You may not construe this question as evidence of anything, right? So we wind up inconveniencing him to make him do his job, and he goes back and he swears out a proper request.
Yeah.
And here's the punchline.
My
Some of
first subpoena.
And here's the thing: we would have gotten that subpoena anyways. So it's like it was inevitable. There would have been something.
But I understand the strategy is just like, well, if you let me in, then you can't ask me to leave, and then I can just keep asking for more. There's no lawyers, there's no paperwork. It's in that situation that you were talking about from the very beginning. Get it in writing.
There were threats. I mean, he indicated, he told us that he's capable of going to JFK and shutting you down.
Yep.
Right?
I mean, damn.
And this was in the lobby, and so there's people walking by in the entire building, and I'm getting yelled at by this large man.
And then he said, and when I got on the phone with him, "You don't want to wind up in court." And I'm thinking, that's exactly where I mean, I'm cooped up in my office every day.
That was kind of our best comments. Like, well, lawyers kind of like it on the court.
Really?
too.
That's
Please,
like
you know?
it's like, please, whatever you do, don't
The code.
Please.
don't touch that
Arguendo.
briar patch.
Arguendo's the code. 10% off for the Adafruit store. Help pay our legal bills. Help protect you at Adafruit.
So the punchline was that some of the information that they based all of this on was simply mistaken, like typographical errors.
Yeah, it was
sort of
Yeah.
mistaken. So remember, folks, when anyone tells you if you didn't do anything wrong, you have nothing to be scared of, the answer is, that may be, but I am scared of you making a mistake. So
That's good advice.
That's good advice.
Okay. All right. So switching gears, we got through pretty much all the things and a lot of the questions in the chat. Thank you. People are learning a lot.
Oh, I actually have another question.
Oh.
So we talked about patents, and you said, basically, for your tweeting mailbox, for example, it could be, 2 years, 4 years.
Did you make a tweeting mailbox? Because you really...
No, he mentioned a tweet.
Oh, okay.
He did.
Yeah, it's a long felt dream.
Okay.
He wants a
Unrealized.
tweeting mailbox.
Do you think that's a patentable idea?
Do I think a tweeting? Where's these glasses? I'll put on these. This is not legal advice glasses.
Yeah.
The thing you have to
or at least
realize.
not correctly.
Yeah. I can change the text. I can change the text that says this is all wrong.
This is all wrong.
Yeah.
The point that you have to remember about patent law in general is that you have to identify what your solution is relative to everything that's come before it. A tweeting mailbox, sort of as a concept, is a mailbox that sort of informs a network that you, I assume, got mail.
Yeah.
And
You've got mail.
and the question is, how does it do that? So
Yeah.
the patent law and patents in general are more concerned with functionality than they are with results. So there's 5 different ways that you can make a screen, right? You can use your old cathode ray, you can use LEDs, you can use plasma. It's all the concept of displaying something.
Yeah.
It's how you display something where the patent inventions lie. So if I come up with an LED display after cathode ray tubes are known, the cathode ray tube guy can't say, well, it's known to display things on a screen. I say, well, of course it is. That's your pioneering concept. What's the patent is how I made the pixels display using something other than a cathode ray tube. So when you build out your tweeting mailbox or any invention, really, it's how is this different than what's come before?
Yeah.
And the patent office gives you this sort of bright line test, which is new and non-obvious. And new meaning there isn't exactly the same thing just sort of sitting on a shelf someplace. And non-obvious means you didn't just slam together, the toaster and the thing that makes the little Egg McMuffins together and say, look, it's a completely new invention because I just essentially duct tape 2 ideas together.
Yeah.
But they're both operating independently of one another. It's sort of that integration, how you would sort of take the waste heat from your toast to cook your eggs.
Yeah.
Might be an invention. And so that's my answer for tweeting mailbox.
No, it's a good answer.
It's a lawyerly answer.
Okay.
But let's say it's like, okay, I don't necessarily want to spend 4 years waiting for this patent. Maybe I know it's not patentable. Maybe I'm like, I don't believe this is patentable anyways. I don't want to risk the $8,000. But maybe I have like the best idea for the name, like tweet mail or something.
Can I answer this?
And then, so I'm like,
We have a
maybe-
trademark lawyer in the house.
So would a trademark make sense, and what does a trademark protect, and how much does that cost, and like how does that
Okay.
compare with
So-
this patent?
So like a
option?
lawyer, I'm going to pretend to answer your question and talk about what I wanted to talk
Okay,
about
yeah,
the
fine.
entire time. All right. So this is really about kind of know yourself or know your idea or know what makes money in the kind of business that you're going to go into, right? So there are some businesses that are very, very it's really branding that makes the sale. So like if you're the 18th apparel manufacturer targeting this demo, it might be totally branding, right? And if you're a restaurant, it may just be about your own skill set, totally unprotectable skill set of being a good chef. If you're the first person to do, a touchscreen for a smartphone, perhaps you have a monopoly and a barrier to entry with patentable technology, right? But maybe it's not going to be that. Maybe your understand what your true advantage or the advantage you could create is. It could be branding, right? It could be or if you're in a commodity thing, it might be something kind of irrelevant, like copyrightable design. So we know a circuit board manufacturer who was in an open source situation where it was not going to be able to prevent offshore low-cost manufacturers from competing successfully with the client. And I said, well, look, maybe take the circuit board and the parts that don't need to be marked for functional reasons, use tiger stripes or leopard spots or some completely abstract idea as a form of branding and copyrightable, differentiation. So know who you are, know what your product is, know how you make sales, and try to get to any of the IP theories, trademark and the child of trademark, trade dress, which is like the appearance of a product. And I give Toblerone as a Toblerone bar is the best example, or the tastiest example of trade dress.
But Kit Kat came up in the news not too long ago.
So for the intermediate course, I would get into scoring of a chocolate bar is functional.
Yeah.
So
But the Toblerone shape is completely not a functional thing. It's just.
it was an arbitrary situation,
shape.
and if you look at it and you go, oh, that must be a Toblerone bar. Coke bottle tends to be the most famous example, although I suspect that there's functionality in both fluting and the concave aspect of it.
Yeah.
People certainly say that things are arbitrary, but there's certain shapes. An Eames chair or Barcelona chair, some of these things have lost other forms of IP protection, and people recognize the shape, which may suggest that it's trade dress. So know what kind of IP, and perhaps an IP lawyer could tell you, but create moats, barriers to entry, the right one. Pick
Unique
the appropriate
shape, unique
ones.
name.
Could be.
A lot of things. Okay, so I'm going to speed round this because we're right on the dot with 1 hour, and we get billed by the hour, I think. So I want to make sure now.
Not tonight.
Yeah.
Because not legal advice.
Yeah. So we have open source compatibility questions. We got actually through everything else. So I'm going to ask these two, and then the last one, and just jump in. So open source compatibility, use of third-party names to indicate interoperability, compatibility. Like if someone wanted to say like Intel Inside, people.
Or like it works with Legos. Something
Yeah.
you can plug into Legos. It's not made by Legos.
Good.
How do they say?
Don't answer yet.
Oh, wait, sorry.
Know the terms of any license that come with the software or hardware. So we release stuff under MIT license usually. And then the last one, policing. Good practices, we're dealing with intermediaries like Google, Amazon, and Alibaba. So if you see something of yours, a name, we have to do that sometimes. So we see things on eBay. It's not made by Adafruit. It says Adafruit, so we use the Varia system. We have to verify that we have the trademark, and they notify the seller, and they take it down. So for this market, the first two, use of third-party names, know the terms of a license. What are the things to consider?
I'd rather answer the intermediary question because
Oh,
it's
yeah.
the last one you did, so it's the top of.
Yeah. Google,
Last
Amazon,
in, first
Alibaba,
out.
eBay.
All right. So this is a reason to have a registered trademark. A lot of these intermediaries, Google, eBay, Amazon, they do not want to get into the question whether you are the true Adafruit.
Yeah, we
What
have
they
to
do
send the
want,
real
and
paperwork.
Alibaba, I guess, is the, I was going to say worse, but that would be pejorative.
They're the most prolific.
Yeah. So they're going to ask for a trademark, very often a Chinese trademark. It solves a lot of steps. Are you the real Adafruit? Well, here's my registered trademark. So that is a good reason to get one, so that you can have these various intermediaries who by now, virtually all of them have structured takedown forms online somewhere. And that's something where I will even say within earshot of you, don't always need lawyers.
eBay is self-serve if you spend the time.
Right. So there's the argument to get a registered trademark.
But we
get
can't
these
do it. We have to submit
intermediaries.
that. We have to actually submit the trademark. They require that.
Correct.
Yeah.
Right.
Yeah.
Now, another reason to have tiger-striped products in your packaging, something copyrightable, is that sometimes people don't necessarily counterfeit you or even use your name, but they do take your artwork, a picture of your product or a picture of
Yeah,
your package,
that's happened to us.
in order to sell their thing. And then it's very useful to use the DMCA, as bad a word as that is. It's very useful to be able to say to Amazon, look, I ain't going to go round and round with you whether this is a counterfeit, but this is my packaging, so please, this is my copyrighted photograph, so please take it down. And Amazon and other intermediaries are responsive to that. So that's the ways of dealing with intermediaries.
Yeah. Okay.
What was the first one you asked?
The
That
fir-
was-
the
I
first
had an
one-
answer to that too.
No, it's good. The first one, and I'll give an example. Use of third-party names to indicate
Compatibility.
Yeah. So what if I wanted to make a product and it's Raspberry Pi compatible?
Okay.
I don't own Raspberry Pi trademark.
Enough to tell the truth, not too much to confuse.
Okay.
That is the compatibility issue. If it is truly Raspberry Pi compatible or Arduino compatible or whatever, you are allowed to say it. Do not incorporate the third-party trademark into your name.
Do you have to? Do you put the TM if you say like Raspberry Pi compatible?
Just,
you put
let's say I
TM.
make a robot for Raspberry Pi. Could I call it the Raspberry Pi robot?
So the name of the product cannot be the Raspberry Pi robot.
Okay.
It could be Lemore's robot, but the packaging and the text can say truthful statements about interoperability or compatibility or replacement parts.
So say Lemore's robot uses a Raspberry Pi or built with Raspberry Pi.
Go with God.
And then when do people
Go
put
God.
when do people put Raspberry Pi as a registered trademark of the Pi Trading Corp?
So it's part of like the truthfulness. I mean, it's the totality of the situation. If I look at this product, do I mistakenly believe that it's Raspberry Pi, or do I get it? And if you're very clear
Yeah.
that it's Lemore's robot and it's made out of or is interoperable with, then that could be enough. But to help yourself and to create evidence that you are a good person, then you could say at the bottom, Lemore is a trademark or registered trademark of Lemore. All other trademarks are owned by their respective owners.
Okay. And then don't use the Raspberry Pi logo, for instance. That doesn't make sense.
So on the whole, you try to use the minimum amount necessary to truthfully communicate.
You don't need to use the logo to communicate that, so don't use it.
There you go.
Okay. All right.
Good guidelines.
So the next one is know the terms of any license that comes with software or hardware. So I'll give a quick horror story. People will take our open source code under an MIT license, do find and replace her name,
I remember that one.
and then say, yeah,
It's already open source, but they still take my name out.
and argue about, well, it's open source, can I just do that? So the terms say, you can't do that, it's a copyright, we have a license. So if you have to be concerned with stuff, what should you be concerned with if you're using software or code and it has licenses?
Yeah, well, the simplest answer is you have to read. These agreements are long and sometimes boring, and they're complex. But the terms in them are there for a reason. People paid lawyers money to put these terms in. A lot of times, what we find is that there are field of use restrictions in hardware licenses. You can use it for this, but you can't use it for that.
Yeah.
Or there's
Open source people hate that because we're not supposed to say you can't use it for nuclear weapons, but if it's open source, you can.
Right, and so sometimes there are patents that come along with open source hardware, and they'll say you get a royalty-free license for this field of use,
I've
but
seen that too.
but you can't use it for X, Y, and Z because we built it to sell commercial product for X, Y, and Z. And
Not
so,
for puppy crushing.
right, or just the humidity sensor, the humidity sensor in our product line we really like, and we sell to government installations because it's a really secure thing.
Yeah.
We don't want you just selling the same product, so we're going to give you a license and we're going to make it open source, but you have to read those terms to make sure that you don't step on their toes, because that's their condition. And everybody can write their own terms, or you can sort of follow along with the MIT licenses as much as you want, but those provisions have to be in there to protect the person producing it.
And GPL is one of those interesting ones where you touch it, now you're part of it.
Right.
And so there's very specific things you have to do, and the open source world lives and dies by people releasing that code. So you hear stories all the time. Hey, Sony, okay, I know you have this Linux thing going on, you're supposed to release it, and they're like, okay, fine, and they bury it on their site somewhere that you can never find.
Yeah, well, it was a big problem with Goldman Sachs, sort of high frequency trading software, and it ended up being one of the first cases where there was a criminal indictment for theft of trade secret. There was a Chicago coder who had some GPL open source Linux code that they were building a high frequency trading platform for Goldman Sachs, and he got poached by another commodities firm, and he took it all with him, only the GPL code that he was supposed to essentially put back in, released to the wild.
Yeah.
And when he tried to do that, Goldman Sachs stepped in and said, that's a trade secret. You're about to release that to the wild. We're suing you. And he got pulled off a plane by New York marshals, and he got held downtown.
Was Richard Stallman there?
An open source Marshall.
In spirit.
So
Okay.
what happened in the end? Did what happened with the GPL code? Was it a trade secret?
Are we all
or were
running
they- were
GPL
they-
high frequency trading right now?
No,
Oh.
it went into a black box someplace, because the Goldman Sachs went to court. They got an injunction on the release of it because they said it was sort of integral to their platform that they were developing.
Whoa.
And it just sort of it sort of ethered, and he sort of fought a long time, and he got convicted, and then the conviction got overturned, and I think he's back up now on appeal because they sort of re-overturned it on another theory. So you sort of have to be mindful that it's not only sort of the terms of the agreements that you have, it's the person who's operating behind those agreements has sometimes an agenda.
Maybe talented programmers shouldn't work for Goldman Sachs.
There is.
We're not allowed.
No, you're not allowed to say that. No, but I'm just saying it's very lucrative. But okay, here you are. How lucrative?
now
How lucrative
you're getting
is
pulled off
this?
a plane by
Yeah. How much would that person pay not to get pulled off a plane?
Well, he was getting paid.
Okay, maybe it was enough. All right. Okay. All right. So as far as the licensing and the code, what are the open source viewers here who release their code? What's a good practice for them to do when they're putting their code up? What is the thing that they should consider? Number one.
I always think commenting on your code is sort of an important thing to just start with, and just sort of start with where your edits are, what the functionality was. When was this? I tend to not write a whole lot of GPL code, but if I do write code, I generally put it. My edits go in with a date, just so that I know what I was doing when I was doing it and why. That way, if someone else picks this code up, they know that these modules, these libraries, this Python bit that I got from somebody else, this is where it came from. Just so that, as being a lawyer, I'm somewhat specific about how the terms of that license should apply and how they apply to me.
Now, if you don't put a license on it, what is it? And this is a trick question, not really, but if you just put code up on the internet, no license, who owns it?
The question is how well you can source it.
You wrote it from scratch.
You wrote it from scratch. Then copyright sort of functions as your. It's
like writing a book.
Yeah,
It's your writings.
independent authorization.
So trademark is an intellectual property that if you do not police it, you can lose it. It becomes a common word and so on.
Everyone says Xerox, tissue,
Copyright,
Kleenex.
you cannot lose it through failure to police really, nor patent.
So it's yours.
Right? I mean,
It's default yours, not default not yours.
Right. So I mean, there are fact patterns where you could wind up acquiescing, and if someone relied on your not policing it and they built $1 million business, you're not supposed to sandbag people through your failure to police. But the mere act of initially not producing it.
Yeah, this is why open source is so neat, because it uses copyright in such a brilliant way.
Right.
It's your code.
uses it.
It's your code that you're licensing, and the people who use it have to stick to that license because you're letting them use it under these terms. So you can make the world a better place by releasing your code, and you can have people be forced essentially to contribute and give back, not counting the Goldman Sachs thing, but that's why this works. It's interesting.
You mentioned the your customer who had developed the technology and the hospital technology.
Yeah, that was Chris.
All right. So you said, well, what could this person do if he's concerned? Well, one of the things he can do, I mean, in a large situation, Linux is a certain model where there becomes a trademark, and it says, if you use this code and you follow these enumerated requirements, then you may refer to this as Linux.
As Linux, yeah.
Right? And that is a way of making sure that people who are only complying with your desire are allowed to at least, they may be able to use the technology, but they can't really use your code, and they certainly can't indicate that they're endorsed by Linux. And the biggest crack up that we know of is when, Java sued Microsoft because they said, well, no, what you're doing is no longer Java. You're forking
Was it Oracle? Was it Oracle and Google?
It was, well, that's a more recent
All the
problem.
giant monsters are suing each other.
Well, this is maybe 15 years ago that Oracle purchased Sun. You know what? This may have been pre-Oracle. So this was Sun released Java, and it believed that Microsoft had what it was doing was in fact a forked version.
Gotcha.
So they're saying, well, look, you may be allowed to do this from a copyright point of view, but you can't call that Java, which would be quite a blow.
Yeah, we're in trademark land too.
Yes, that was the theory. So
Yeah.
my point is that in order to still release it, but also to somehow influence what occurs to it in the wild, a certification trademark.
Yeah.
It's not a plain vanilla one. Certification.
Yeah, Oshawa does that now in their open source license. Like, if you meet all these terms, you can possibly call it,
You have the logo, you can use the logo.
In our case, the only time that this comes up is when someone removes Adafruit from all the code, removes Lamore's name, posts the code and says, hey, this is from us and our product. And it's a lot of fun. Good times. Okay, so we're going to wrap up. Jordan, Marty, closing thoughts. Any other things for these makers that are tuning in? And this is the first time they've actually heard lawyers. No one does this, by the way. So thank you, of course.
You're the first lawyers to be on our show.
Yeah.
Hopefully not the last.
No, you can come back every week.
Excellent.
What other closing thoughts do you have for the makers out there that might be considering a
Tips
patent?
and tricks.
Yeah, because you're in the patent world.
The answer that I always give to inventors who call me up or that I meet is you sort of know your idea and be comfortable in your idea. If you're still casting about for what it is, then you're not ready to talk to a lawyer, you're not ready to start a business. But once you're sure, once you've sort of really sort of crystallized it down, you've built it, that's the time to start getting your ducks in a row. And there are ways of doing that that a lawyer can help you out that don't necessarily involve filing a patent, but there are ways in which a lawyer can sort of help you at least sort of chart how you're going to do that and what your strategy is and what your business is going to be about to help you sort of take that idea and make it the best that it's going to be.
Okay.
Pretty good
Marty,
advice.
in the world of trademark copyrights and your specialization.
Well, really, it's more about lawyering, which is, or more accurately, being a consumer of lawyers, which is that there's this huge reluctance to not go to a lawyer because they are thought to be expensive. And if you approach a lawyer and they feel that they're only going to give you 10 minutes of their time to assess it, and then maybe they're not the right ones. I mean, in our firm at least, our view is that we kind of do not wish to bankrupt you, the first week that you're with us. That's a project, that's a multi-year goal of ours. and that you come to us, and if you are too early, we will tell you are too early, and if you're too late, then we'll refer you to another firm. No, but it's a trusted counsel relationship, or at least it works when it's a trusted counsel relationship. And you guys should know that this is hands down most organized, best relationship that we have. These guys, we work on the relationship. And the point is that they trust us. And these are good clients.
And to wrap up, here's our story before we do a giveaway.
They got to feel the love. That's what we're getting to.
So one of the reasons that we're all here is Bunny, who's an open source hardware pioneer. He just wrote a book, and it's called The Hardware Hacker, Adventures in Making and Breaking. We could do a whole other topic one day about reverse engineering if you want to come back. but Bunny gave Lamore some of the best advice when a guy was threatening her, because he said he invented Pong or something, and we have a clock that played Pong, and he didn't even own Pong. He made an art project, and
He didn't even have a lawyer send me a letter. He just sent a letter.
no, just threatening. And this is the first time that Lamore has ever heard someone threatening about her business. And Bunny was in town, and he said, the 8th time that I went to court. So he's been through a lot of stuff. And he said, the judge told him, listen, MIT smart kid, if you're smart enough to make the money, you're smart enough to protect it. And Bunny said, you should talk to a lawyer. And he's since written these books. He's doing all sorts of neat things about fair use and your right to take things apart. And so Bunny was at the start about 10 years ago when Lamore first got told, no, you can't do that. And it was a mean person, and they didn't have a lawyer. They just sent threatening emails. And his advice is what we really try to do. We want to protect this special thing called Adafruit, even though we give everything away. Don't say you're Adafruit. Little things like that. So we're going to give away this book. And the way we're going to do this is going to be fun. So for the folks that have a telephone, we're going to give this away. And you just call this number, OMBIT-STAB. And we're not going to answer it right away because I want to turn on the microphone. And let's
Is there a
see what
payphone?
happens. Yeah, we have a payphone. So let's see if this works. Okay, Lady Ada, answer the phone after the second ring. Ask them their name.
Yes.
Oh, wait, not yet.
When you're ready.
I have so much stuff going on here.
Yeah, I know.
Okay, go for it.
Ready?
Yeah.
Hello, you've reached Ask the Engineer and some lawyers. Who are you? What's your name and where are you calling from?
Hi, this is Jonathan. I'm calling from Miami, Florida.
All right, well,
Can you repeat the name and where they're calling from?
This is John from Miami, Florida.
All right.
Yeah,
Woo,
and
Florida.
congratulations, John, from Miami, Florida. You have won a copy of The Hardware Hacker by Bunny Wang. It's an awesome book. We're excited to give it to you. Thank you for calling in.
Okay, don't hang up.
I'm not hanging up yet.
So if you call, because we're going to go soon, if you call and get the voicemail, leave us a nice voicemail. We play those on the air.
Yeah.
In fact, we're going to play one out when we go.
But for you, John, if you want to win your prize, email support@adafruit.com.
Yeah, please.
SUPPORT at adafruit.com and say, hi, I'm the John from Miami who won the book. And we're going to send you this book.
Awesome.
Awesome.
Thank you guys for everything you guys do. This was a really cool and interesting video. Segment. It was really cool learning about laws and the lawyers
Maybe tell
and
John
stuff.
to wrap it up.
Because it's something that a lot of people don't know about, and I think it's very valuable.
That's why we love having them on the show. Well, thank you so much for calling and keep tuning in. We're going to wrap up this show, and don't forget to email to get your gift.
All right, thank you.
All right, go ahead.
Outstanding.
Okay.
Okay.
He said it was very interesting to hear about law because he doesn't know that much.
Excellent.
Cyber lawyers.
Okay.
So we've
with
given
that
away the
being
book. Thank you, John,
yeah,
from Miami.
So that being said, thank you so much, Jordan and Marty. Not only have you been great to Adafruit, but I think this is the first time that makers got a chance to hear all this. And one of the things we like to think is, like, internet is great. Cat videos are fine. All this stuff, these buy buttons and this consumption is fine. But imagine if everybody just spent maybe 1 hour a week and learned about legal stuff. Would we be better businesses in a less litigious world? What if there was other types of shows every single week? Because now there's no channels. It's not cable. This is on 5 different internet networks. And so the only way that works, though, if there's an audience who wants to listen, which we have, and then people like you who are professionals who do this every single day, and it's tedious because I have to give you a lot of information, and you ask over and over for a lot of details. So thank you so much. Because without people like you who are professionals who do this for a living, sharing this information, it might be impossible for us, at least because it's in the news as a nation, to really start to have manufacturing and people starting businesses. That is the engine.
Open source hardware. That's all good stuff.
And we often have the conversation with people, well, I don't want to do open source because there's no way it can be a successful business. And that's simply not true. You can protect some things and you can give away some things. You can be a good cause and a good business. So thank you so much for being here, and we'll do this again if people are interested. Leave a voicemail about these great lawyers.
First off, thank you for having us on, and thank you for being great clients. We can't do this without clients, legally. And
We'll try to get in some good fights.
and for you guys out there, eternal vigilance is the watchword of liberty. Know your rights, and we'll leave it at that.
Yeah. Lawyers love defending rights.
Come back with a warrant.
All right.
No. All right. So that is Ask an Engineer, everyone.
Thank you,
Thank you so
everybody.
much. We're gonna play a voicemail on the way out from a couple people, and that's it.
Good night, everybody.
Bye bye.
Know your rights.
Just calling to say Happy Pi Day, and hope you're having fun in the snow.
Hi, Lady Ada. My name's Rebecca. I'm a huge fan of you guys. I love your products. And hopefully I can get on not Ask an Engineer Live, Show and Tell this week. But I love what you're doing, and I want to be just like you. So, have a great day.